Hello everyone, welcome to Lukmaan IAS. Today we are going to have the Hindu newspaper analysis dated 6th of August 2022. Today we are going to discuss some of the most important topics that were there in the newspaper today. So let us quickly look into the topics that are important. Okay. So the first topic that we are going to take for discussion is RBI raises rates, vows nimble policy. Okay. So RBI stands for the Reserve Bank of India. So it has increased the repo rate. So in this article we are going to understand about repo rate and its relation with inflation and monetary policy. Okay. So this topic is important under Indian economy. After this we are going to take the next topic that says SC moots verdict for bodily autonomy. Okay. So recently the Supreme Court of India has given a judgment, and that judgment is related to bodily autonomy for women to go for medical termination of pregnancy. Okay. So in this article we are going to look into what is medical termination of pregnancy act, and we are going to talk about various things associated with this particular act. So this topic is important under Indian polity and also for the Indian society of GS paper 1. Okay. And also it is important under social justice, okay, for GS paper 2. With this we are going to take into another topic, take into consideration, this is sticking to commitments. Okay. So this particular topic is important under environment and ecology, and in this topic we are going to understand about the next conference of parties, okay, to the UNFCCC. So we are going to talk about what is UNFCCC, we are going to understand about different conference of parties, we are going to talk about the Paris Agreement, and we are going to learn about intended nationally determined contributions, which is also known as INDC, and we are going to understand like where the next UNFCCC conference of parties is going to be held. Okay. So this is very important topic under environment and ecology. After this we are going to take another topic. It says privilege of MPs does not extend to criminal cases, says Venkaiah. Okay. So recently Venkaiah Naidu, okay, he has told about what are the different types of immunity available to the member of parliaments. Okay. And we are going to talk about how are the member of parliament also immune from criminal offences. Okay. We are going to talk about the role of enforcement directorate, we are going to talk about the CBI and all, and we are going to understand how these things are making news nowadays. Okay. So this topic is important under Indian polity for GS paper 2. After then we are going to talk about Kashmir issue should be resolved peacefully. Okay. So we are going to talk about the third anniversary. Okay, third anniversary related to conversion of Jammu and Kashmir from a state to union territory. Okay. So we are going to understand about the revocation of Article 370 from the Constitution of India, and we are going to talk about various factors associated with this, and we are going to talk about what was the stand of Chinese government on this particular development. So this topic is important under Indian polity and also for the international relations. Okay. Why? Because the Chinese government has given some statement under this. After this we are going to talk about another topic. It says a fresh opportunity. Okay. A fresh opportunity. Why? Because recently the data protection law, okay, which is also known as the the protection of the digital data. So related to that there was an act, there was a law that was in draft condition, and that law was formulated in 2019. Okay, before that there was another act. Okay, so that was formulated in draft format in 2018. So in this article we are going to talk about data protection laws in India. We are going to talk about Justice B.N. Shri Krishna committee. We are going to talk about Justice Puttaswamy versus Union of India case, and we are going to talk about what is the recent development related to data protection laws in India. So with this let us take the first topic, which is related to an Indian economy. Okay. So let's take the first topic for discussion quickly. So it says RBI raises rates, vows nimble policy. Okay. So RBI stands for the Reserve Bank of India, and Reserve Bank of India is the central bank for India. Okay, so this is the central authority that regulates all the it regulates all the banks in India. Okay, be it foreign bank in India, be it scheduled commercial banks, be it non-banking financial companies. So the entire banking sector is regulated by the Reserve Bank of India, and Reserve Bank of India plays a greater role when it comes to monetary policy. Okay, monetary policy for India. So recently, under the new monetary policy that the Reserve Bank of India has come up with, so in that particular monetary policy decision, RBI has decided that they are going to increase the repo rate by 50 basis points. Okay, so we are going to understand what do we mean by basis points. We are going to talk about what is repo rate. Okay, repo rate is the rate of interest that Reserve Bank of India charges from the scheduled commercial banks, from the banks when Reserve Bank of India gives loan to the commercial banks. Okay, so Reserve Bank of India is the central bank. It gives loans to the scheduled commercial banks, it gives loans to other type of banks. So when it gives loans to those banks, Reserve Bank of India charges some interest rate from them, and that interest rate is known as repo rate. Okay, it is known as repo rate. Repo, it stands for repurchase obligation. Okay, repo stands for, okay, it is known as repo rate. So repo rate is the rate at which Reserve Bank of India lends money to scheduled commercial banks or to other banks in India. Okay, so Reserve Bank of India has increased the rate of interest, okay, the repo rate, by 50 basis points. 50 basis points means 50% of 1%. Okay, means like it is 100 basis points. 100 basis points is equal to 1%. Okay, 100 basis point is equal to 1%. When we talk about 50 basis points, okay, 50 basis points, so it is 0.5%. Okay, 0.5%. So it has increased the repo rate by 50 basis points. Earlier the repo rate was 4.9%, but after the revision the repo rate is 5.4%. Okay, so 5.4% is the rate of interest that Reserve Bank of India is going to charge from the scheduled commercial banks. Okay, so repo rate is a very important indicator. Okay, it is a very important indicator. So why Reserve Bank of India increases the repo rate? Okay, as you know that like inflation has been hitting highlights. So in various newspapers you might have heard about that, inflation rate, rate of inflation is going high. So inflation is increasing, on month. So that's why Reserve Bank of India has come up with this policy. Okay, to curb the inflation. Inflation means when the prices of goods and services are increasing. Okay, so you have to pay more money to get the same good or get the same services. Okay, how to curb inflation? By increasing the repo rate. Okay, when Reserve Bank of India increases the repo rate, so in that case banks have to pay more money to borrow from Reserve Bank of India as interest. Okay, when banks are themselves paying more interest rate to Reserve Bank of India, so they will be charging more interest rate from the consumers. When consumers are, or when customers like us are going to take loan from the scheduled commercial banks. So when we take loan, if the rate of interest is very high, so we will try to avoid taking loan, or the taking loan will be costly for us. Okay, so the thing is slowly and gradually the demand for goods and services will little bit go down, and it is going to curb the inflation. It is going to reduce the inflation level in the economy. So this was the thing, this was the news. And if we talk about this graph, the graph that is shown over here, okay, this particular graph shows us the repo rate, okay, from August 2017, okay, from August 2017 till, okay, this month, August 2022. So they have shown how the repo rate has changed over the last 5 years. Okay, how it has changed. So in August 2017 the repo rate was 6%, then in 2019 it has gone beyond 6% also, it was more than 6%, but slowly and gradually the repo rate was decreasing. So like there was a time when the repo rate was 4.9%, it was 4.5% as well. But now the Reserve Bank of India has started increasing the repo rate. Okay, so before this change, like Reserve Bank of India has already increased the repo rate once. Okay, so this was the second increase in the same quarter. Okay, we would say. So now the repo rate is 5.4%. Okay, so this is the interest rate that the Reserve Bank of India is going to charge from the scheduled commercial banks for the loans that they are going to talk about. Okay, so that they are going to take. Now the Reserve Bank of India is also of the opinion that like they are going to withdraw, they are going to withdraw the accommodation, means like so there are some accommodative policy stance where the Reserve Bank of India does not change the interest rate, but like this time it has changed, it has increased the interest rate. So you can read this article in your free time, you will understand about various nuances related to Monetary Policy Committee of the Reserve Bank of India, and also you will be able to relate the role of the Monetary Policy Committee, the role of repo rate, increasing, decreasing repo rate, how it affects the inflation level, and like also we have a reverse repo rate. Reverse repo rate is like vice versa, when the Reserve Bank of India borrows money from the scheduled commercial banks. In that case, the rate of interest that Reserve Bank of India pays to the scheduled commercial banks is known as reverse repo rate. Okay, so with this, let us take another topic for discussion. In that article, they have talked about the consumer price index. They have talked about current account deficit and all. You can read the article, you will understand it. Okay, so with this, let us take another topic. It says Supreme Court moots verdict for bodily autonomy. Okay, rules under MTP Act permit pregnancy termination up to 24 weeks in 7 categories. Okay, so now let us understand about details of this particular act. So like recently the Supreme Court of India has given a judgment, and in that judgment the Supreme Court of India has upheld the recent provisions of the Medical Termination of Pregnancy Act. Okay, the Medical Termination of Pregnancy Act 1971. So if we talk about this particular act, the Medical Termination of Pregnancy Act, so this is this act has been enacted for the first time 50 years before. Okay, this act is more than 50 years old, and that time when they have formulated this act, so they have used the keyword husband. Means let's consider if there is a lady who needs to abort any of the fetus that she has. Okay, if she is pregnant, she wants to abort the fetus, in that case, right, so she should be a married woman. Okay, so like in the act they have mentioned that the keyword husband. Okay, so it means like a married woman could go for abortion under medical conditions. Okay, so that is known as the Medical Termination of Pregnancy Act. Okay, but recently the government of India and the legislature, Indian legislature, they have changed the provision, they have updated the provision in this particular act, and instead of the keyword husband, they have used the keyword, they have used the keyword as partner. Okay, they have used the keyword partner. Okay, so partner signifies any male partner of the women. Okay, it signifies someone, it signifies the relation beyond marital thing also. So there can be a woman who is unmarried, but she is pregnant, but now she wants to terminate the pregnancy. Okay, in that case she will come she will come under the provision of this particular act. So Supreme Court of India has said that we should not have any discrimination towards women who are unmarried. Okay, because the medical conditions remain the same. Let's consider there is a married woman, and that married woman has some complications related to her pregnancy. So she can abort it, but up to what time she can abort the child? Okay, she can abort the child up to 24 weeks of pregnancy under this particular law. But in the same law, they have mentioned the time period to be 20 weeks if in case the women is not married. Okay. So the Supreme Court of India said that like this grossly violates the bodily autonomy of the women. Okay, so like we should not look into whether the woman is married or unmarried. We should look into the medical condition that the woman is going through. If she needs to abort, so the law should be same for women, married women as well as for unmarried women. Okay, so this was the opinion of the Supreme Court of India, and this particular judgment was given by two judges. One of the judge is Justice D.Y. Chandrachud, and second judge is Justice J.B. Pardiwala. Okay, so these two judges have, I mean, like, you know, given the judgment in the Supreme Court, and they have said that, like, you know, we should uphold, okay, the bodily integrity of the women, and we should, you know, give them same protection irrespective whether they are married or unmarried. Okay, so this is the opinion of the Supreme Court of India, and they have, you know, mentioned about multiple things. And if we talk about the Medical Termination of Pregnancy Act, this particular act allows for, you know, termination of pregnancy under 7 conditions. Those 7 conditions, okay, those 7 conditions are, you know, those 7 specific categories include survivors of rape or sexual assault, minors, and in case of physical disabilities and fetal malformations, etc. Okay, so this is the thing. Okay, so this is the thing. Now the Supreme Court of India is of the opinion that, like, you know, so like if a woman is unmarried, they should also be given chance to, I mean, like, you know, abort the child at par with the laws that are applicable to married women as well. Okay, so with this, let us take another topic for discussion. Here in this article, we are going to understand about what do we mean by sticking to the commitments. Okay, what kind of commitments? Okay, so we are going to talk about the kind of commitments, like why we should stick to the commitments that we have already made and all. So this article is important under Environment and Ecology section of the UPSC you know, GS paper 3 for the mains exam, and this is also important for the prelims exam. We are going to talk about a lot in this article. So let us understand, right, this article. So the thing is, like, the government of India has taken commitments for itself in 2015 in the Paris Agreement. Okay, in 2015 Paris Agreement, the government of India has agreed that, like, it is going to put effort you know, in reducing the climate change. Okay, in reducing the climate change, and that effort will is known as intended nationally determined contribution. So the thing is, at that point of time, the government of India has decided to take 8 different measures, 8 different types of measures, so that, like, you know, we can help the global community in reducing the climate change. Okay, so that, like, we can keep the climate change below 2 degrees centigrade you know, when compared to pre-industrial level. Okay, so that time, like, you know, we have made commitments, and these commitments were made in the Conference of Parties, okay, to the UNFCCC that has happened in 2015. This Conference of Party was conducted in Paris. Okay, it was conducted in Paris, so it is also known as you know, Paris Agreement. So Paris Agreement was a kind of joint agreement by different participating countries. So India has also agreed that we are going to, I mean, like, we are going to take multiple measures, and these measures will be reviewed by the same country, okay, by the country that has taken commitment every 5 years. Okay, so they are going to review it. Okay, so that time, like, you know, we have taken, you know, 8 specific targets for ourselves, and those targets included, okay, those targets included that, like, we are going to reduce the emission intensity of GDP by 35%, okay, by 2030, and we are going to have 40% of the installed electricity capacity sourced from renewable energy. We want to create an additional carbon sink of 2.5 to 3 billion tons, okay, of CO2 equivalent through forest and tree cover. Okay, so now these were the commitments that were made by India in the Paris Agreement. Okay, these were the commitments. But now why are we talking about it? Because like recently, very soon, we are going to participate in 27th Conference of Party. We are going to participate in the 27th Conference of Parties, which is of the United Nations Framework Convention on Climate Change, okay, which is also known as COP27. So we are going to participate in it. So where is it going to be conducted? It is going to be conducted at Sharm el Sheikh. Okay, it is going to be conducted at Sharm el Sheikh. It is the name of a place which is located in Egypt. Okay, so the Conference of Parties COP27 is going to be held in Egypt at Sharm el Sheikh. Okay, so in November, okay, in the month of November. So we are in August now, and this particular meeting is going to be conducted in November. So at this point of time, the Union Cabinet has approved India's nationally determined contributions, a formal statement detailing its action plan to address climate change. Okay, so ahead of this particular meeting, ahead of COP27, the Cabinet Committee of India, Cabinet Committee, okay, Union Cabinet, okay, they have approved India's nationally determined contributions, okay, and it is a formal statement detailing its action plan to address the climate change. Okay, they have already approved it now. Okay, and why is it was necessary? Because like in 2015, 7 years back, we have committed to something. We have committed to reducing the climate change. Okay, we have committed to, I mean, like giving our effort for reducing the or mitigating the climate change. Okay, so now let us understand about like what has happened in the recently concluded. Okay, so like last year we also had COP26. That COP26 was conducted in Glasgow in 2021. Okay, COP26 was conducted in Glasgow in 2021, and in Glasgow the Prime Minister of India, okay, Mr. Narendra Modi, okay, he has laid out 5 commitments, and those 5 commitments were named as Panchamrit, okay, Panch Amrit, okay, it was named as Panchamrit. Okay, these were 5 commitments, and they have named, the government of India named it as Panchamrit. And these 5 commitments included India increasing its non-fossil energy capacity to 500 gigawatt by 2030 and achieving net zero by 2070, and no net carbon dioxide emitted from energy sources. So these were the commitments made by the government of India in 2021 in COP26. But now what is ahead in COP27? Okay, for COP27 we have already formally approved the India's nationally determined contributions. That was a formal statement. Okay, but apart from this like after years of negotiation and international pressure and clear evidence of the multidimensional impact of climate change have been seen, India agreed to move away from fossil fuels over time. Okay, so like India has also moved with the progressive ideas of adopting the renewable sources of energy, looking forward to alternative sources of energy, and also sidelining the fossil fuel based energy slowly and gradually. So this is the thing, this is a very important topic. Okay, so in this article we have understood about multiple things, like where the next Conference of Party is going to be conducted, what has happened in COP, in Conference of Party which was conducted in Paris in 2015. We have also understood about the commitments made by India in COP26 that has happened in Glasgow. Okay, so with this, let us take another article for discussion. Okay, so now let us understand about this topic. It says privilege of MPs does not extend to criminal cases, says Venkaiah. Okay, Venkaiah Naidu. Okay, so wrong notion about immunity from action by agencies when House session is on. Okay, so Venkaiah Naidu, right, he has been the chairman of the Rajya Sabha. okay, being the chairman of the Rajya Sabha, so he looks into the affairs, how the members of the Rajya Sabha, respond and react to different situations in the Rajya Sabha itself. Recently, you might have noticed that, like, ED is conducting raids in multiple places, and it is summoning, high level officials of the government of India. Not only officials, but even parliamentarians are also summoned by the enforcement directorate, and also CBI is also conducting investigation in multiple cases that involves some of the high level politicians. So the thing is, like, many politicians were of the opinion, they were of the view that, like, they are immune from any criminal investigation when the house is in session. What do we mean by house is in session? We mean that, like, when the Parliament of India is conducting business, when the Parliament of India is deliberating on different topics, I mean, like, they are conducting discussion in the house of the Parliament. So that is known as, like, house is in the session. So during the house in the session, the parliamentarians or the member of parliaments, they are immune from civil offences, they are immune from civil offences. But the thing is, like, proceedings can also be there against them after a certain notice period. But when it comes to criminal offences, right, so none of the parliamentarians are immune from it. So Rajya Sabha chairman Mr. Venkaiah Naidu made it clear that, like, those parliamentarians, those lawmakers, right, who are citing that the house is in session, so they should not use this excuse. So if any enforcement agency, like, the enforcement directorate is trying to conduct any investigation, if they want to summon any parliamentarian, so the parliamentarian should cooperate with them, and they should attend those those summons, okay, they should attend those summons, and they should not simply, I mean, like, do away with this, okay. And Mr. Venkaiah Naidu made it clear that, like, parliamentarians are the lawmakers, so they should also avoid the they should also abide by the laws, okay, by the acts, by the rules, regulations that are in place, okay. So parliamentarians, being lawmakers, they should be the first ones to abide by the procedures established by law, by the statute books, etc., okay. So, like, enforcement directorate and the Central Bureau of Investigation, these agencies has been in news time and again, and, like, many opposition party members, okay, so they are of the opinion that, like, these top level organizations like enforcement directorate, Central Bureau of Investigation, these are being directly operated by the central government in such a manner that, like, opposition party members are put behind the bars, okay. So, like, allegations are put against them, investigations are being conducted against them, and the opposition party members, okay, so they are of the opinion, they are of the view that, like, these agencies are being used by the government to hamper or against the opposition party members. So this is the thing. But the Rajya Sabha chairman has made it clear that law is equal for all when it comes to criminal cases. Like, all MPs are at par with a normal citizen of India, okay. Normal citizen and the MPs will be considered equal, okay, in those cases. So this is the thing. You can read about this article in your free time. And so, like, if we talk about which article of the Constitution of India talks about privileges that are, I mean, like, privileges that are available to the member of parliaments, okay. So Article 105 of the Constitution of India, it talks about the privileges that MPs means member of parliaments enjoy, so that they can perform their parliamentary duties without any hindrance, okay. And one of the privileges is that member of parliament cannot be arrested in a civil case, okay, and 40 days notice, okay, 40 days before the commencement of the session or committee meeting, and 40 days thereafter. This privilege is already incorporated under section 135A of the Civil Procedure Code, okay. So this is the thing. But, like, when it comes to criminal matters, the member of parliaments are at the same footing as a normal citizen, okay, in front of law, Okay, this is the thing. So with this, let us take another topic for discussion today. So in this article, we are going to talk about what is the stand of Chinese government when it comes to revocation of Article 370 from the Constitution of India. Okay, so it has been 3 years. Okay, so like we have celebrated the third anniversary. Okay, third anniversary of of revocation of Article 370 from the Constitution of India. So on that occasion, one of the spokesperson, okay, the lady that you can see in the image, okay, she is the spokesperson, okay, she is the spokesperson of Foreign Ministry, okay, Foreign Ministry of China, okay, and she has said that these two countries like India and Pakistan should resolve the resolve the disputes between them amicably. They should peacefully do dialogue. They should negotiate over any dispute that they may be having related to Kashmir. Okay, so why she has said? Because the thing is we have revoked the special status of Jammu and Kashmir that was available under Article 370. Okay, we have revoked, and it's been 3 years that it has been revoked. So so after revocation of the special status, Jammu and Kashmir became similar to a normal state, but after then we have changed them into 2 union territories. So we have union territory of Jammu and Kashmir, and we have union territory of Ladakh now. Okay, so why Chinese government has talked about it? Because there are multiple connotations. What are multiple connotations? On one side, it is being considered that China takes the side of Pakistan many a times. It is being considered by India. So when it takes this side of Pakistan, then Pakistan also gets emboldened. Okay, it gets emboldened, and it tries to showcase its strength, okay, along with China towards India. But the thing is India being a sovereign country, so it does not come under pressure of any nation, be it China, be it Pakistan, etc. Okay, so the thing is since Jammu and Kashmir was an integral territory of India, and so we have revoked the special privileges that was applicable, okay, that was given, okay, to Jammu and Kashmir under Article 370 of the Constitution. So the thing is, this is just a statement that was made by her, but the thing is we did have some kind of tensions with China, because People's Liberation Army, which is also known as PLA, so it is the army of China. They have tried to transgress, okay, they have tried to enter into the bordering areas of India in the northern portion of India. So that time we had some kind of strained relationship with Chinese government because of the tension created by liberation by the Chinese army, okay, in the LAC. LAC stands for line of actual control. Okay, line of actual control is the border, okay, bordering area that separates India from China. Okay, so this is the thing. We will not go into much deeper thing in this article. So this can be considered as a foreign policy, a news item on international relations. With this, let us talk about another topic. This is going to be the last topic for discussion today. So in this article, we are going to understand about a fresh opportunity. Okay, bill's withdrawal is a chance to check lacuna, but a data protection law brooks no delay. So now let's discuss about this article in detail. So what does this article want to talk about? It says the stated reasons for the government's withdrawal of the Personal Data Protection Bill 2019 was that it will come up with a comprehensive legal framework on data privacy and internet regulation. Okay, so now let us talk about this particular act, Personal Data Protection Bill. Okay, so the government of India have come up with this particular bill in the year of 2019, Personal Data Protection Bill. But the Personal Data Protection Bill has some historical some previous connotations also, before this personal data protection bill 2019, we also had another bill, that bill was 2018 bill, okay. So that 2018 bill had certain provisions and 2019 bill also had certain provisions, but 18 bill provisions were, you know, more acceptable to many members, but the 2019 bill, okay, they have changed certain keywords, they have, you know, made certain modifications, but later on, like when it went for a scrutiny, so like, you know, many people have negated, many people have, you know, given dissenting opinion, they have given, you know, opinions against, okay, this particular bill. So that's why recently the central government of India has withdrawn this particular bill, 2019 bill, and they have said that like they are going to come up with a new bill, okay, they are going to come up with a new bill, and that will be a comprehensive legal framework that is going to talk about data privacy and also internet regulation, okay. So now, you know, the Supreme Court of India has given, you know, certain guidelines related to Justice K.S. Puttaswamy versus Union of India case, okay. In that case, the Justice, you know, K.S. Puttaswamy, so Justice K.S. Puttaswamy, he was a judge of a high court, but, you know, he retired, and after then, like, you know, he has filed a complaint in the Supreme Court of India related to, you know, right to privacy. So, you know, this particular case is known as Justice K.S. Puttaswamy versus Union of India, and in that particular, you know, judgment, the Supreme Court of India has given landmark, okay, it has given landmark guidelines based on, you know, personal data privacy, okay, based on principle of, you know, privacy, and these principles were in line with the, you know, with the fundamental rights that are available with the, I mean, like, citizens of India. So after this, okay, so after this particular judgment, the government of India has framed a committee, they have, you know, framed a committee, and that committee was known as Justice B.N. Sri Krishna Committee, okay. Why Justice B.N. Sri Krishna Committee? Because Justice B.N. Sri Krishna was the chairperson, he was the chairman of this particular committee, okay. And so it was a committee of experts that had authored the draft bill in 2018, okay. So like the Justice B.N. Sri Krishna Committee was a committee of experts, they have drafted the Personal Data Protection Bill 2018, okay. So for overemphasizing the national security angle among others, okay. So they have drafted this particular bill in 2018, but the thing is, the government of India did not accept that bill as it is. So they have, you know, made multiple changes in that particular bill, they have come up with those changes, and those changes were like when it, you know, like made open for the public deliberations and all, public had criticized a lot, there were, I mean, like, you know, multiple member of parliament in the, you know, parliament itself, they have opposed this bill. So it is still a bill, it has not become an act, but recently the government of India has withdrawn this bill, and they said like they are going to come up with a comprehensive legal framework, okay, that's going to deal with the data privacy and internet regulation related things, okay. So like in this article they have mentioned about, you know, the key differences between 2018 bill that was produced by the expert committee and the 2019 bill, okay, that government of India came up with, okay. So in this article they have mentioned that in the 2018 bill they had mentioned the keyword security of the state, okay. So they had a particular provision that said that, like, you know, it allowed for exemption to be granted to state institutions from acquiring informed consent from data principals or to process data in the case of matters relating only to the security of the state. But later on in the 2019 bill, they have also included this public safety, okay. So I'll just, you know, talk about that keyword. So they have come up with public order, okay, instead of security of the state, okay, they also added a keyword that is public order. So public order, like many people were of the opinion that like this particular keyword public order as a reason for exempting the government agencies for using the, you know, private data of the citizens will, I mean, like, you know, give the government an open hand, okay, in misusing the law, okay, in misusing the law that is there, okay. So and apart from this, like there are multiple other things. Okay, so many member of parliaments, many MPs, they have given their opinion against this particular bill. So dissent notes to the JPC report by Congress MP Jairam Ramesh, okay, went in to criticize the leeway granted to the government on exemptions, how the ground of public order and not the security of state was liable for misuse. Okay, so like multiple parliamentarians, they have talked about like why the keyword public order can be misused by the central agencies, by the agencies of the government. Okay, this is the thing. If the government is intended to commit if the government is indeed committed to a comprehensive legal framework on data privacy and protection, it must revert to the baseline provided in the Justice Sri Krishna Committee recommendations and enact a law within a reasonable time frame. Okay, so this was this is the opinion of the author. So author says, like, if the government of India wants to come up with comprehensive guidelines, okay, if he wants to come up with comprehensive guidelines related to data protection laws, related to regulation of the internet, so they should go back to the recommendation of Justice B.N. Sri Krishna Committee, and after then they should come up with a law at its earliest. Okay, they should come up with law quickly. Okay, so this is the thing. So with this, like, we have discussed all the topics for the day. Thank you so much everyone for attending today's session. I hope you have a good day ahead. Thank you.